Good afternoon or good morning, everyone. Thank you so much for making a time to attend our session today. For those who don't know me, my name is Christina Swan, and I am a director of the Chartered Governance Institute of Canada, but I'm living and working in Bermuda. It's my pleasure to introduce Kim Wiley. I have worked with Kim over the last 15 years, not only while I lived in Vancouver, but while as colleagues here in Bermuda. Kim currently resides in Victoria, but is called to the bar in British Columbia and Bermuda. She advises as a consultant senior legal counsel, including with the Bermuda law firm ASW Law Firm. She also teaches business associations law as an adjunct professor at the University of British Columbia and the University of UVic. Kim further has a PhD in the University of Cambridge, an LLB and MBA from the University of Victoria, and the Master of Law from Osgoode Hall at York University out of Toronto. Kim's research is in corporate governance, accountability, and focuses on diversity, sustainable business models, and reducing short-termism in equity capital markets. She's also the esteemed author of the text, Stock Market, Short-Termism, Law, Regulation, and Reform. Thank you so much, Kim, for making the time and presenting this very informative session. Thank you.
Thank you, Christina, and it's great to be here, and it's really excellent to see the number of participants that are interested in this topic. And I see some familiar names and faces from both Canada and Bermuda, so it's great to see everyone, and it's great to be here. And so the topic today is beneficial ownership, what it is and why it matters. And I do think it's interesting because when Christina and I first talked about this, I think I got a virtual eyebrow raise at whether or not this would be a topic that would draw interest. But I think today it certainly is evidence that it is an important topic, and it is something that is front of mind for each of us as governance professionals. Okay, so what I'd like to do today and how I'd like to use the time is to walk through, first of all, just setting the stage around what exactly we're talking about, and then look at some of the reasons why we as governance professionals are interested in beneficial ownership and some of the drivers around the beneficial ownership reporting regimes in various jurisdictions. Including a bit of discussion around the international story of beneficial ownership and how that's impacted local jurisdictions. And then, given that we have people from practicing in Bermuda and various parts of Canada on this presentation, I want to look at some specific measures in Canada around beneficial ownership and some recent developments across Canada, and then also specifically Bermuda. And I think this discussion and this analysis will be quite helpful because we'll be able to see what's happening across jurisdictions and draw some comparisons and perhaps learn some lessons from the different approaches. And then finally, I wanted to place this beneficial ownership discussion in a broader context and discuss beneficial ownership as it relates to various other kind of pressures that we see in international business and corporate governance. And particularly here, we'll look at some of the measures around privacy and data protection. And finally, as Kathleen and Christina were saying, we'll have some time for questions. Given that we have such a large group on the call, I would ask that you hold questions until the end. And then if you could put questions either into the chat or raise your hand, and we'll try and get to many of the questions as we can as time permits, but we will attempt to answer all questions if we don't get to them in the time after the presentation. So lots of text on this first slide about what beneficial ownership actually is. And essentially here, the concept is that the entity benefiting from a particular asset is separated from the ownership of that asset. And there is lots of text and lots of information intentionally in these slides, and we will be able to provide a copy of these slides for people after the presentation. So I pulled two definitions, one the legal definition, and the other the definition from an Investopedia, which sets out kind of a more kind of business perspective on beneficial ownership. I find Investopedia as a useful go-to for business definitions and concepts. And beneficial ownership is different than registered ownership. So in the context of shares, registered owners are the owners who appear on the register, the share register. For land, it would be the party that actually appears on title. So when we talk about registered ownership, that's different than beneficial ownership. The person who may be entitled to the benefits of that ownership may not actually appear on title or on the register. So essentially, it's a separation of ownership and control. So why do we care about knowing who the entities, the beneficial owners are? And I've pulled out three main reasons why we as governance professionals may be concerned about beneficial ownership. And there's a lot of specifics about why we may gather beneficial ownership information in the legislation in each of our different jurisdictions. But everything boils down to sort of one of these three principles. And when you're thinking about gathering beneficial ownership, it's important to think about these different rationales. And the first, and I think it's arguably the most important, and it's not dictated by any specific type of legislation, it's the business risk. So if you are a governance professional for a specific organization, or you work on behalf of clients in a law firm or as a corporate administrator, understanding who you're doing business with is really important from a reputational perspective. And that's not just the person who you appear to be directly contracting with. Going deeper and actually understanding who the decision makers are is really important from a reputational perspective, aside from any anti-money laundering or kind of tax reasons why you may be compelled to gather that information. The second area is obviously AML, ATF, which is, as governance professionals, we're all very intimately familiar, with the requirement to vet ownership, and there's specific legislation around how we do that, how we're regulated, and why, and what the rationale for gathering that information is. And this is the sort of classic know your client requirements. And finally, tax. So it's really important for taxing authorities to understand who owns an organization and who's benefiting economically from that organization. And there's obviously specific requirements and legislation around exchange of information from a tax perspective. So these are the three main areas. And these have also been identified in the Financial Action Task Force, which is a global organization that looks at corruption from a global perspective as being the reasons why we're concerned about beneficial ownership. So with that backdrop, I just wanted to, before we go into looking at some of the international drivers, show you this very complicated organization chart, which is a public document coming out of the Panama Papers. And this is a classic example of a complicated ownership structure. And I'm sure as governance professionals that you're looking at this, making lists already in your head about the type of documentation that could be required for each of these entities, and thinking about the sheer number of hours it would take to vet this type of ownership structure. So this type of complexity is certainly not unique in terms of international corporate structures. And there's often layer upon layer of ownership built into a structure before you actually find out who the ultimate beneficial owners are and the people, the individuals behind a structure that are making decisions and benefiting economically from the organization. So in terms of the international drivers which have led to the development of beneficial ownership regulation in various jurisdictions, we could probably spend an entire hour just talking about these international pressures, but to give you a very brief overview of what the key drivers are, I've pulled out the G20 principles that came out in 2014, which set out some very high-level principles on beneficial ownership transparency, including building on the recommendations of the FATF, that's the Task Force on Financial Action around beneficial ownership. Then we had some situations in the market where we had information compromised that was held through service providers. And as a result of that, we had very public information, both in the Panama Papers and in the Paradise Papers, which provided a very public format for ownership of offshore jurisdiction, offshore entities, of entities in offshore jurisdictions, which created a number of issues for corporate structures, but also really upped the pressure from international organizations to increase transparency. So there weren't organizations that were able to essentially shield their ownership structure from taxing authorities. Coming out of this, and the discussion was already well underway, and the Panama Papers and the Paradise Papers really just kind of provided more impetus for the implementation of these measures. We saw European-wide directives requiring each jurisdiction in Europe to have public registries. And there's some great tools out there if you're interested in the measures in specific European jurisdictions. I think one of the global law firms, Denton's, has a type of tool where you can put in multiple jurisdictions in Europe, and it will actually give you the beneficial ownership requirements in each of those jurisdictions and a comparison of the differences. So beneficial ownership registers throughout Europe in 2018, and those are public. So those are publicly accessible registers. So if you want to find out the ownership of a particular European structure, you're able to access the public register and gain access to that information. 2019, we've had an additional meeting of the OECD focused entirely on transparency and the exchange of information. And this is essentially taking those European provisions around public registers and increasing the pressure globally to have public registers in OECD jurisdictions. And finally, it's not a specific kind of international kind of discussion yet, but it is worth mentioning COVID-19 and the impact that is going to have in this space. Governments are looking to ensure that taxes are fully collected, and public transparent registers will aid in ensuring that beneficial owners are identified and appropriately taxed. So that's increasing the pressures not only for proper beneficial ownership reporting, but for transparency and public registers as well. So now moving specifically to where we are with beneficial ownership in Canada, 2017, kind of aligning with international measures, we had an agreement by the finance ministers across Canada to focus on strengthening beneficial ownership requirements and transparency. I've included a link in the presentation So you can read more about that particular agreement, because that's been the basis of the beneficial ownership regime in Canada. There's a lot of text on this slide, but this is the Canada Business Corporations Act provisions, which came into effect in 2019, in June of 2019. And I'll just quickly go through these requirements because they're very similar to what we would see in other jurisdictions as well. So with these provisions, they're applicable to private companies. So public companies are not included for reasons that public companies are obviously very, very widely held. And so beneficial ownership is not as relevant in those structures. And companies that are federally incorporated need to create a register of ISCs, individuals with significant control. This register needs to include certain information, which includes the ISC's name, birth date, address, tax jurisdiction, and the dates and basis of their ISC status. It's a two-part test. This is similar to what we see in most beneficial ownership legislation in various jurisdictions. The simplest test is 25% interest. So that's voting control or economic control. So you don't necessarily just follow through the votes in a structure, you look at the economic interest. So that might be preferred shares or some other form of economic interest in a structure. And that can be a little more challenging to figure out. If you don't get to any individuals that have that threshold of 25%, then you look at influence or control in fact. And again, this is a very similar criteria that we see in other jurisdictions, and is often challenging to determine what this type of influence or control in fact may be, maybe through a particular voting agreement, for example, at a level throughout the structure. This ISC must be maintained and updated, and there are fines and including prison for non-compliance. So they have put some teeth behind these requirements. Currently, this is a really important provision. Access to this register is limited. So it is limited to the director under the CBCA, tax authorities, police, and there was a lot of discussion when this was implemented, and those of you practicing in Canada are probably very familiar about who should have access. But police, RCMP are included as persons who may have access to this register, as well as shareholders and creditors. So it is limited, is not public. It's not something that you can search. And if you do want to have access, it has to be for a specific, either one of these specific categories, so that it is used for specific enforcement purposes. Each of the provinces in Canada has agreed to have some type of beneficial ownership register. To date, as far as I'm aware, BC, Saskatchewan, and Manitoba and Quebec have all taken steps towards a beneficial ownership register. Others on the call today may have knowledge of other jurisdictions that are also taking steps, but these are the key jurisdictions that have progressed their beneficial ownership regime. Interestingly, in the budget that was just released, the federal budget, there was an allocation for $2.1 million to implement a publicly accessible registry by 2025. So for all the international kind of reasons that we've been talking about, and I think we can't discount the need for increased tax revenues as a result of COVID, we are looking to have a publicly accessible registry at a federal level in Canada by 2025, which is coming up very quickly. But we don't yet have details about what that would look like. So I wanted to spend a little bit of time talking about what's happening in BC, because BC has beneficial ownership in two contexts. One is the Transparency Register. So this is the Corporations Act, and this came into effect in October 2020 as a new part in the legislation. This excludes public companies like we saw at the federal level, and also extra-provincial companies. So for companies who are set up in other jurisdictions in Canada, who are registered extra-provincially in BC, they're not caught by this specific part of the legislation. The substantive requirements are quite similar to what you would see in the CBCA, but slight differences around access because it relates more to provincial authorities as opposed to federal authorities. Again, this isn't a public document. So like the CBCA, this is a document that is maintained for specific purposes and access is limited. However, we know that the move is towards having this be fully public. The other part of beneficial ownership in BC that's worth mentioning, because this is somewhat unique as a jurisdiction, is the Landowner Transparency Registry, which came into effect in November 2019, but is in the process of being implemented and updated as we speak. So this is under specific legislation, and I've included a link in the presentation as well. And this relates to land and any changes in title to land, to property in BC. And in any changes to property in BC now, there needs to be disclosure around the individuals behind any corporate entities. So that needs to be filed with the registry in BC. This is a publicly searchable registry. So if a corporation owns land in British Columbia, it's required to report who the individuals are behind that corporation. And for a $5 fee, any member of the public can search and find out the ownership of that corporation. So it's not a full public registry in BC because it only relates specifically to entities that hold land, but it's certainly a step towards a public register for corporate entities. And reporting bodies have until the end of November to ensure their information is correctly put into that system. Wanted to talk about Quebec as well, because Quebec is in the process of looking at this issue and has come up with a distinct process in terms of beneficial ownership. And I don't practice in Quebec, so I will start with that proviso. I expect there may be people on this call who are more familiar with the structure in Quebec than I am. But essentially, the process in Quebec is to come up with, and what's proposed is a registry that where you enter the name of a natural person. So if you enter my name, Kim Wiley, into this publicly searchable register in Quebec, you would then get a listing of all the corporate entities with which I am associated. So a slightly different type of process in Quebec than we've seen in other jurisdictions, which essentially flips it, and you would need to know the name of the corporate entity first before you would be able to find out any information about who the individuals are associated with that corporate entity. Bermuda. And beneficial ownership in Bermuda is interesting, and because the jurisdiction has such a long history of actually already collecting beneficial ownership. There's 70+ years of the Bermuda Monetary Authority collecting information on the individuals who are associated with a particular corporate entity. And this has been done because of exchange control rules that are in place in Bermuda, which are somewhat, is a somewhat different regime, and governance professionals practicing in Canada than they would be familiar with, because we don't have in Canada the similar types of restrictions around exchange control that is in the Bermuda regime. But in 2019, beneficial ownership was introduced into the Companies Act in Bermuda. So separate from the exchange control regime, there was a beneficial ownership register requirement that was built into the Bermuda legislation. So this is information that is maintained and updated by Bermuda companies, and a copy is filed with the Bermuda Monetary Authority. Interesting point here too is the role and the relationship between the Bermuda Monetary Authority and the Registrar of Companies. The Bermuda Monetary Authority, as I've noted, is responsible for the exchange control regulations and has been gathering information on both sort of indirect ownership information and ultimate beneficial ownership registration for quite some time. The Registrar of Companies has had more traditionally a registrar role around the incorporation and the setup of corporate vehicles. And essentially you provide your incorporation application, you meet all the requirements, you get your certificate of incorporation or other corporate documents. And so this change to having a beneficial ownership register is starting to change the function and the interplay of these two organizations. Currently, because exchange control was already in place and because information was already gathered by the Bermuda Monetary Authority, it makes sense for that type of information to continue to be gathered by the Bermuda Monetary Authority. But legally speaking, this is a requirement of the Registrar of Companies. And when the Bermuda Monetary Authority gathers this information, it is doing so as an agent for the Registrar of Companies. And this new type of role for the Register of Companies, and we also have in Bermuda provisions around economic substance and determining the substantive connection of a business to Bermuda, is starting to put the Registrar of Companies into more of a regulatory role rather than sort of a pure registrar, rather than just registering information. So this is an evolving space. And what role the Registrar of Companies and the Bermuda Monetary Authority are going to play going forward in terms of collecting and vetting and reviewing information around beneficial ownership. What information goes into this register is the name, nationality, residential address, and date of birth of the ultimate and beneficial owners. And the threshold, similar to what we've seen in the Canadian legislation, is around 25% ownership or control. And if there is no such individual, then control by any other means. And so often what we see here is we see a corporation at the top of a corporate structure, and within that corporate structure, there isn't any particular shareholder or individual that has 25% ownership. So you're not able to very clearly say, this is the individual behind that structure, in which case you naturally look to the board of directors of the corporate entity at the top of the structure and say, is it this particular board that's making the decisions for the group as a whole? Are there also executive officers in this structure that run the day-to-day operations of the group? And there is a determination that needs to be made in terms of which individuals should be included in that beneficial ownership register. Currently, and again, this is a really important point, this is not a public document. So you're not able to go to the Bermuda Monetary Authority or the Registrar of Companies and search to find out who is on this beneficial ownership register. It's limited, access is limited to parties who have a need to know that information, in particular around taxing authorities, and there's specific requirements if a particular taxing authority makes a request in Bermuda to have access to specific information about a beneficial owner. And so it's not yet publicly available. However, Bermuda is an overseas territory associated with the United Kingdom. And you know, if we go back to that list of all of the international pressures, there are requirements and there are pressures on the United Kingdom. The United Kingdom has publicly accessible beneficial ownership registers, and in order to meet their international requirements and to comply with their legislative requirements, the UK has passed legislation which compels all overseas territories to establish public registers. So that's not just Bermuda, but the Cayman Islands as well, and each of the overseas territories is compelled under UK law to have public beneficial registries. This has created some political tension in Bermuda around self-governance and the ability to have control over these types of decisions, which is a really interesting discussion, and probably not one that we're going to get to in any detail right now. But it's just important to note at this stage that the Bermuda government, in response to this pressure from the UK, has agreed to table legislation for a public register by 2023. So there's a bit of flexibility in that language. It's tabling legislation. It still needs to go through the Bermuda legislative process, which obviously has its own built-in checks and balances. There's some additional language that the Minister of Finance spoke to as well about international standards, and Bermuda not necessarily wanting to be out on the forefront of this until there had been some clarity in terms of the international position. That leads nicely into this next slide around competing concerns. And here I think is where things start to get really interesting. And we could spend a considerable amount of time talking about each one of these bullets. The first one is privacy laws. And this isn't an issue specific to Bermuda or Canada. This is certainly an issue that there are concerns in each and every jurisdiction. So on one hand, we see this rising pressure to disclose the individuals behind a corporate structure for various valid reasons, like we've mentioned, to stop money laundering, terrorism financing, to understand our business risks, to assist with ensuring that taxes are properly paid, all valid reasons. But at the same time, this rise of wanting to ensure that information, particularly information around individuals, is properly protected. I think all of us, when we think of our organizations or ourselves personally, can think of some concerns if our information, if we control a corporate vehicle, was made accessible to the public. One reason that always comes to mind to me is just the flood of marketing requests that you could get and emails that you could get if people know that you're essentially a high net worth individual and you have control or ownership of a corporate structure, and that information is out there. It makes you much more visible in terms of kind of points of contact from maybe unwanted contact with people trying to sell you things. Not to mention, extremely serious concerns around privacy, around safety concerns. We've heard numerous examples of people who have set up corporate structures to avoid having their personal name kind of out in the public sphere, particularly in certain Latin American countries where there's concerns about their personal safety if that information is available. So there's very valid reasons about why we may be concerned about having that information available in a public sphere. And we've seen legislation and regulation rising to support those concerns. So here we have an example of the tensions between the two. this pressure to have that information readily publicly available, combined with the interests of protecting individuals' right to privacy. And this is a tension that we see playing out in the legislation. An interesting point is that if we do have requirements for beneficial ownership registers to be made public, we will have to have language in the enabling legislation, which essentially overrides the requirements in privacy legislation. When privacy legislation is enacted in Bermuda, we're still waiting for the Personal Information Privacy Act to become operative. But in Canada, certainly we're seeing that this language is incorporated in specific legislation already and would need to be looked at if the registers were to go public. Another issue, and we actually do have, I think I saw Carol Prest on the line, who's the Registrar of Companies from British Columbia. So once I'm kind of finished the presentation in a few minutes, I'd love to kind of have her give her perspective. But another kind of big concern, big picture concern with having this type of information be publicly available is sort of what I call the garbage in, garbage out problem. So if you have this type of information and no independent vetting of that information, you still have a lot of the same issues. You have the ability for false information to be put into a system, and you don't have a way of kind of relying on the data that's being presented. So having some type of means of authenticating the information that's in a system would make the system that much more useful. If we are going to have this type of register, then if somebody enters, the individuals behind the structure, just entering their name and address, rather than having specific confirming documentation behind that, may not be as effective. I often think when I'm working with clients who have companies in the UK, and yes, there is a beneficial ownership register that is publicly accessible, but you really have no way of knowing once that structure gets outside of the UK. So if you have a UK company and then you have, say a corporate entity in Luxembourg, and then perhaps one in Malta, and then some individuals who are based in a different jurisdiction, that the information, once you go beyond the UK level, is accurate or verified in any way. So having some type of means and international standards around the information that's inputted and vetted makes the whole system function. Otherwise, you end up with sort of an information overload with no verification. Another point that I just raised, probably because I teach business associations and I walk through this concept of limited liability with my students on a regular basis, is the whole point of setting up a corporation, and the reason we have these statutory provisions and essentially the social contract is because corporations are limited liability structures. So the whole point is that you can't sue the shareholders. So and we have 100 plus years of court cases looking exactly at this point. And there are very limited circumstances where you're able to pierce the corporate veil and find liability for individuals behind that corporate structure. So although we understand the very valid reasons for wanting to understand who these individuals are we going too far in terms of having this information be publicly accessible? Because ultimately, these individuals, from a legal perspective, are not the persons who you would name in a lawsuit against the corporation. It's the corporation itself. And are we sort of fundamentally undermining this principle of limited liability if we're putting such pressure on identifying the individuals behind the structure? But again, that's probably the subject for an academic paper. But I do think it is an interesting point on whether or not this focus on beneficial ownership is aligned with the intended purpose of limited liability of a corporation. And finally, I sort of touched on this when I was talking about the authentication piece. Does this make sense if it's done piecemeal? Or is what we really need a multi-jurisdictional approach where we all agree this is the definition of beneficial ownership, which to some degree has been done through the OECD, but there's nuances in every jurisdiction. Or additional standards on the type of information we should be gathering from beneficial owners and how we should vet that information, perhaps some sort of centralized exchange of information. But then if we as jurisdictions defer until there is an international standard, that's passing the buck so far down the road that it becomes a non-relevant point. And at some point, we just have to kind of put together a piecemeal system and improve it as it's happening. So I hope that this presentation has given you a bit of insight into what beneficial ownership is and why it matters, why we're talking about it, why it's at the forefront of people's minds, and how complex an issue it is as well. And also, I have a lot of sympathy for regulators and registrars, because this is a complex issue. It's not one that's sort of originating from the regulators and registrars. It's coming to be because of all of these different international pressures. And I think understanding and explaining kind of those drivers about why this information is being collected, and understanding some of the pressures on why that information should be limited, and why public access may also need to be kind of monitored and looked at, I think are really important for us as governance professionals. Now, I don't want to put Carol on the spot, but I'm going to, because we have the benefit of having Carol on the line. But Carol, you're sort of living and breathing this as the Registrar of Companies in BC. So I'd love your thoughts for just a couple of minutes, if you don't mind.
Well, I think you're absolutely right. The garbage in, garbage out, Kim, and really believe that if a beneficial ownership registry is going to be developed in Canada, there should be proof not only of and maybe audit in the back end, but certainly in British Columbia, we have the BC Services Card, which you've referenced, which creates a verified credential for individuals, and leveraging that across the beneficial ownership registry, and even within the corporate registry, we are starting to use the services card for identifying the completing party. So when someone is registered or incorporating their business, we are looking to have proof of identity. So as a starting point, that is kind of the beginning of our approach. And for beneficial ownership, it's absolutely critical to know that yes, this person is the correct is a correct person, and not a fraudster or someone whose username and password has been compromised. I would from the perspective of multi-jurisdictional, absolutely, if we don't have alignment across certainly within Canada, but also internationally, we really run the risk of not being able to do the due diligence, because if everybody has different rules, and you're trying to find out, is this beneficial ownership who has these corporate structures around internationally, how do we find that individual? And we won't be able to do it if we all have different rules and different parts of information. So it's in my mind, some of the things that we are talking about in British Columbia is specifically around what are the things that we can do to create a better and a more robust approach to truly understanding if this is truly something that government has committed to. Canada's made the commitment, the Financial Action Task Force, this is international. There's a drive towards this. So let's not do something that will not be a coordinated approach. It doesn't make sense if everyone's making the same commitments. Thanks, Kim. That's all I wanted to add.
Yes, and I think that's a great point that, it is coming. It's a commitment that's been made at international levels, national levels, by provincial governments. Like it or not, it is happening. And we will not only have beneficial ownership registers in each of these jurisdictions, but at some point within the next few years, I would expect that these registers will be public. It's what we see in Europe right now and in the UK. And it's what I expect we will see in Canada and in Bermuda. And it is going to be interesting with these, particularly around privacy and the tensions that are there, how this can be done in a way that minimizes that impact. But ultimately, one set of legislation is going to have to take precedence. You can't have your cake and eat it too. So if registers are going to be public, there's going to have to be a provision that says the information in the privacy legislation doesn't apply. And then the question becomes, what information is public? Interestingly, what we see proposed in the Quebec legislation is that the information is very limited. So it's essentially the name is public and a business address, not a personal address. And that's perhaps one way that we might see some of these issues mitigated, is to have restrictions on what's publicly accessible. But I think there's very valid reasons, and we'll see kind of strong arguments being made by the government that, particularly in Bermuda, that there's reasons for this information to be kept private. It is accessible. If people do need to know, they can use the proper channels. But ultimately, having it fully public has risks and concerns. Whether or not that'll be enough to stand up to the international pressure, I don't know. But it is going to be interesting to see how this develops. One thing I think as governance professionals that we might like is if we're doing KYC on a counterparty and we live in a world where beneficial ownership is all public, it's the press of a button, right? And if we're using a compliance agency to vet counterparties, and all you do is enter, a corporate name, and it sort of behind the scenes kind of does all the work for you, and you get a report that you can rely on that will search the BC corporate registry, the Quebec registry in Luxembourg, one in Bermuda, and it'll tell you very clearly, it'll generate that sort of Panama Papers picture, and it'll show you the entire corporate chart. And so in some ways it could make our jobs easier. It's just a question of how that information, how we can rely on that information, if we can rely on that information. I'm just scrolling through to see if there's any other questions coming through on the chat.
I have a couple a question and a comment. So back to slide number 39, ownership in Bermuda slide.
Yes.
Cassie Blake asks, does the BMA get reports on all Bermuda companies or just investment banking insurance companies?
Yeah, and that's a great question. Bermuda has kind of a sort of complicated process in that there's the exchange control rules, and then there's the rules under specific regulation around shareholder controllers. So from an exchange control perspective, any company that's formed in Bermuda needs to input information right from the registered shareholder all the way up to the individuals that are behind that structure. And that's done in an online system, and that has been collected for 70 plus years. So in that system, you have anybody who holds over a 10% interest, actually, information is gathered on that person. Then we have the Registrar of Companies, the Companies Act requirement that introduces the beneficial ownership register, and that's everybody, individuals over 25%. There are some exclusions on who needs to provide that register. But essentially, for the most part, it is every Bermuda company, with some carve-outs for listed companies and their subsidiaries. So all Bermuda companies provide that information. It's not publicly accessible at the current time, but it needs to be provided. And then there's an additional layer in terms of vetting voting control for regulated entities. So the BMA ultimately collects all that information, but it does so in probably wearing 3 different hats at the current time. I was speaking both with the BMA and the Registry of Companies before this presentation, and shared the slides too, and got their feedback. So this is an issue, obviously, that they're very alive to and receptive to. Unfortunately, the woman who runs the process from the BMA is on vacation this week. So she provided her input via email, but she was very sorry to miss the presentation.
Thank you. Alan Marshall asked, the big question in my view, jurisdiction differences, until the USA as the world's largest economy buys into public registers, the global standard is a mockery. Will Delaware, Nevada, and all other states buy into the public BO registers?
Yeah, and this is, again, not unique to beneficial ownership, right? This is, this is really any international measures. Without the United States, it becomes a challenge. And the United States, because they have a lot of economic weight, tends to do things their own way, and in ways that provide maximum protection to US individuals. And the US's argument around beneficial ownership has been the strength of their tax reporting and their extraterritorial reach. And because of the vigor around US entities and the control they have around ownership of US entities, generally they have not been an advocate for a beneficial ownership register or a public register. So it is a challenge, and it's a big glaring weak spot in international measures. The problem is it hasn't slowed down the OECD or other jurisdictions from wanting to implement beneficial ownership registers. And it goes to that last bullet on my competing concerns slide, is this whole multi-jurisdictional approach. And without the US, what meaning does it have? Arguably, it's coming regardless. And it's just a reality that the US will be taking a slightly different approach.
A comment from Patrice Horner. How about a virtual identity or tokenized data, which will provide the requisite data on an individual basis?
Yeah, I love that. And I've actually seen a few types of kind of software developer programmers who've proposed this exact idea. And I know we actually have one in Bermuda who's been looking at doing like a compliance wallet, where essentially you kind of load all of your personal or your organization details into a specific wallet that can then be shared with your banks and your service providers, and it has everything in one place, so you don't have to constantly replicate it. The challenge is getting that accepted as a standard. But I do think that, if we can put aside some of the concerns about why we might not want a public register, it does, if we do have organizations like the BC Registry and Ontario and Quebec and Bermuda saying this is a publicly accessible registry, those types of tokens become more valuable because they're pulling the information from a trusted source.
And I have one last comment from Lisa Bourne. I live in Trinidad and Tobago, and we recently instituted the beneficial ownership legislation, to which I had to comply with regard to various entities that I manage. It was a nightmare at first, as the forms were so convoluted. We're still trying to come to terms with the new legislation and compliance.
Yes, and you're absolutely not alone. I'm sure if I did a poll and got people to raise their hands on who has been through a similar experience, we'd have a sort of flood of responses. I think everybody has experienced that in some form or another, just the complexity of getting to the bottom of beneficial ownership, which in some ways is sort of the point. right, is that these are complex structures, and we need to give some thought to who is behind these structures, and particularly if there's a trust involved or some other type of more complex vehicle. Anytime I get an org chart and I see a trust at the top, I just think, oh no, because that, you know, bifurcates or trifurcates the compliance, trying to understand who the parties are. And then you have these competing concerns, because a lot of these structures are set up so there isn't anyone in control for tax reasons, so that there isn't tax payable. And so then trying to understand, and you're trying to unwind a complex tax structure at this point, and then fit in the various forms. And going back to that slide about the business risk, AMLTF and tax, you have so many different competing pieces of legislation that all have their own requirements and forms that I agree, it's a hugely complex area. And particularly when it's being implemented. And we saw this in Bermuda and in BC over the last few years. And the first time you look at this, that's really the heavy lifting. And it does need to be updated and maintained. But hopefully the biggest part of the heavy lifting is behind you, and now it's it's a process of onboarding. But yeah, I certainly, with my clients, I build in an extra week or two just to get through this compliance piece in any transaction, because it really is becoming a bigger part of what we do.
Lisa Campbell Congdon asks, with tokens and public registers, is there any scope to place these ledgers on a blockchain where regulators can access at will? Companies
Again, I love that. I think you're probably looking 10 years into the future, but at some point, having some type of kind of live updating system would be fantastic. I mean, could you imagine if you'd set up your share register and your beneficial ownership register, and you could somehow link that name to a registry in BC, and then it would provide you live data constantly confirming. But there are specific compliance providers that are looking at exactly this type of information and updates. The fees for that type of service are quite high, because right now a lot of the searching is done manually. But to the extent this can start to get automated, it becomes a much more useful and cost-effective process. And hopefully one day it's something we'll all be able to manage in-house, and our registers will automatically update.
Looks like one more here. Lisa Ann Fraser. Hi all, great presentation. What happens if a BO cannot be identified? How does a company go about selecting who from senior management should be reflected or named as the BO?
Yeah, and ultimately, like all good complex legislation, there is a subjective element to it. So certainly, what I always say is first of all, go right back to the primary piece of legislation. So in this case, it's the Companies Act in Bermuda, and make sure you're kind of rereading the language so that there's no surprises or misinterpretations. And then there is some helpful guidance as well on beneficial ownership that provides some different scenarios that you can walk through and see if those fit. And hopefully there you'll be able to pull out enough information to make a judgment call. But ultimately, at the end of the day, it could become a judgment call. And then determining and looking at the specific circumstances of your organization and saying, you know what, it's the CEO and the CFO who control this entity, and my other VPs or my other corporate officers are involved, but more for specific purposes rather than from a point of control. So we're going to put the CEO and the CFO as the two individuals, or perhaps there's the chair of the board. So it's really fact specific.
Great. Hi, Raj. Thank you for your question. How do you correlate beneficial, registered, and legal ownership?
Yeah, no, that's an interesting point as well. I mean, beneficial ownership really is removed from the registered or legal ownership, and registered ownership is the name on title, and similarly, legal ownership relates to who's actually listed as the owner. The beneficial is sort of how we determine who has control, and there may be many intervening entities. Sometimes you'll see 10 intervening entities in a couple of trusts that gets you from the registered or legal up to the beneficial. and connecting the dots between those two is a really important part of what we do as as corporate governance professionals. And so having your beneficial ownership register is important. Knowing who's on your share register is important. Equally important is knowing all the pieces in between.
Great, thank you.
Excellent. And I saw that Carol just dropped OrgBook, the link to OrgBook, and I don't know how we forgot to mention that, Carol, but in BC has set up a public version of its register. So it's a really neat way of just typing in the name of a BC entity, and it'll give you some basic details on the legal name of the entity, what type of entity is, when it was formed. It doesn't give you details on who the shareholders are. And again, this was one of the first points. I've gone through this with my law students, and that's one of the questions I ask them is, what doesn't this tell you? Yeah. And that, that is a potential point in the future where we could see details about beneficial ownership being added. And, I'm really excited to see what they're going to be doing in Quebec and how they're going to be rolling out this process where you type in a name, an individual's name, and you get a full list of everything they own in the province in terms of their corporate interests. And that could, be and it'll be an interesting test case to see, how that's used by the market generally.
Raj has a follow-up question there. BO rules apply to private corporations. Where do we see complexity?
Where we see the complexity, yes, the beneficial ownership rules apply to private companies. For public companies, determining beneficial ownership is less relevant because they have thousands often of shareholders and a visible board of directors. So we're less focused on transparency. So when we talk about beneficial ownership, we are talking about private corporate structures, which are by far the bulk of the types of corporate entities that we see in all of these jurisdictions. And then there is considerable complexity in these structures and often layered between jurisdictions as well. And that's where we start to get a challenge is sort of how we connect all of these dots. I think we're probably just at time, aren't we?
So yeah, anybody further? We're okay if we go a little bit over. And
I do have, and it's on the slides, but I have my email address there. So I'm always happy to hear from people. And I do think this is very much an ongoing conversation. So I really hope this has been useful and provided a bit of context about this challenging subject matter.
Thank you very much. We have a final question. I don't know. Do you have time for that, or?
Let's see. It looks like a complicated question. It's a trust. You see, it's a trust question, and it's from Christiane, nonetheless. So, yes, no, absolutely. Where we have situations where a company is owned by a trust, and the trustee of that trust is a licensed entity, then the company is exempt from maintaining a beneficial ownership register. And that's a tricky question in terms of what registration and regulation are we talking about in terms of that trust and trustee. So it's probably better to handle that one offline rather than get into the specifics of it right now. But I think, again, it sort of highlights with trust structures in particular that it's not as simple as just saying, you've got these individuals who are the trustees or the beneficiaries, and we put those individuals on the register, and that's the end of the story. It's a much more nuanced structure when you have a particular entity that's been set up essentially to kind of remove control from certain individuals.